Now, we mentioned that the government kind of retreated on this question a bit, and I think retreat might be the word of the day for these oral arguments on both sides, honestly. But let's stick with the government for a moment here, because I think she was really retreating, the Solicitor General, right from the get-go. There was a lot of talk going into this oral argument about the two standards that might be presented. You had the government's preferred standard, which is law-abiding, responsible. If you're not law-abiding or responsible, then you can have your guns taken away, essentially. And you had sort of the ACLU talking about it, different standard, the dangerousness. You've had other amici. I think you've sort of, as we just went over, talked about a finding of actual dangerousness being required for guns to be taken away. Now, there's obviously questions about how what lifetime prohibitions and things like that weren't as much at issue here. But the government came in and was articulating this, and then immediately had several justices questioning their law-abiding, responsible standard. What did you make of that?
And the question is, well, when you say, and obviously, excuse me, the U.S. Supreme Court, in its major Second Amendment decisions, has certainly used the phrase law-abiding, responsible citizens many times. So when some of the justices said, well, why are you raising that as the standard? I think Solicitor General Prelogar said, well, we got it from your cases, so what are you going to expect?
Right. We learned it from watching you.
Yeah.
Yes.
But she also, in the back and forth, and this was even true in the government's opening brief, that they read that even the government concedes that means dangerous. That if you're not law abiding in the sense that you, as an example we talked about in our brief, is you're a habitual repeat overtime parker. Every day you pay the meter for 2 hours and you stay there all day for 8 hours, and you've been convicted of that 100 times. You're clearly not law abiding in some sense, but it's not really danger that you're creating by doing that. So they seem to retreat on that, but then they take back the retreat by saying basically Congress can categorize anything it wants as supposedly a category of dangerous people.
Yeah, that seems like a pretty big
like
loophole.
Somebody, for example, who uses marijuana but never uses marijuana when they're carrying or shooting or doing anything with a firearm. So what's the danger there? None, obviously, which is why the Fifth Circuit in the U.S. v. Daniels case this summer said the 922 G3 ban on gun possession by anyone who is an unlawful user of a controlled substance. The Fifth Circuit didn't throw that statute out, but they said, as applied to Mr. Daniels, who is a marijuana user with no indication of ever using while intoxicated, as applied to him, you can't enforce the federal gun ban. And of course, the Department of Justice disagrees with that. They filed a cert petition in the Daniels case. So even though they claim they're only arguing for dangerousness, they define dangerousness so broadly as to basically be anything Congress says it is.
Yeah, they also had this conception where she didn't want to say that they only believe in dangerousness. It seemed like because she was trying to preserve these prohibitions on people whose gun ownership presents a danger, but who are not themselves consciously attempting to be dangerous, if that makes sense. So her examples were people who are mentally ill, or people or children was the other one.
Yes.
And so
I think that
seemed to want to go all the way to
a legitimate thing. You think of some
people
dangerous
who are
people.
dangers.
Right, right. So there's some folks who are, the reason they're dangerous is because of the things they intentionally do. They're robbing the liquor store
Yeah.
with a handgun. But somebody who's mentally ill might not be convicted of a crime because they'd have an insanity defense they could raise. Mm-hmm. So you're not ascribing moral fault to that person, but it's still dangerous for that person to have a firearm.
Yeah, that seemed to be why, that was her explanation for why they didn't just say dangerousness, why they said law abiding or responsible because of these other categories. That was her reasoning for why the government went the way it did. But yeah, as you're saying here, it seems like they have an extremely broad definition of dangerousness, and that goes to something, I believe it was Justice Barrett. Actually, Justice Barrett had a pretty good, I thought, rebuttal to the idea that the court came up with the law-abiding, responsible standard. Like, yes, they do talk about how in Heller or McDonald or Bruin that the people affected were law-abiding and responsible, but she said, they weren't necessarily trying to create a standard with that. They were just saying that they're kind of like setting a floor, like these people that are being affected in these cases previously, none of them had any sort of criminal record or anything like that. And that was kind of their way of talking about it. Didn't, at least to Barrett, it didn't seem to set a test. She kind of objected to that. What did you think of that?
Yeah, that's true, but it's a fair argument. But it's also true that in a Supreme Court opinion, every word gets parsed very carefully by the lower courts, and there's rules in basically every Federal Circuit Court of Appeals that even something that is clearly dicta in a recent U.S. Supreme Court opinion is almost as binding as the holding itself. And that's less true as you go lower on the judicial food chain. But certainly the Supreme Court, it's practically like, reading the Bible, in the sense that every little word matters a lot and gets taken very seriously in interpretation. So, that one of the benefits of this case is the Supreme Court can clear up some of that confusion.